Thank you very much. Contrary to my younger previous colleague, I didn't bring my laptop or iPad with me, but the papers, which says something about my age. I would like to start by thanking our Hungarian hosts for this very warm welcome here in Budapest, although this winter is going to be quite cold, it seems. And I would also like to thank Professor Violet, who was the head of my research group this year and the year before. This paper I'm presenting today is not yet published. It will be published in one of the journals issued by the Central European Academy or the affiliated institutions, and it is somewhat narrower than the first paper. The first one was dealing with privacy in all aspects, constitutional, administrative law, civil law, criminal law aspects, and this one deals only with administrative law aspects and not with the privacy as a whole, but with the protection of personal data. So it is in that sense narrower than the first one. Why I have chosen the topic? Well, actually, I wanted to present something which I see as a success story, which is, I know, the case in your countries as well, the protection of personal data within the administrative law system generally functions very well with respect to the infringements that happen in the online environment. I was starting my research by exploring the origins of the duty to establish such a supervisory body. And as you can see on the slide, in the international context, this duty to establish such an authority can be traced back to 1991. So there was a non-binding resolution of the United Nations General Assembly, which was adopted unanimously. And this is the first international data protection text that includes this requirement of an independent data protection authority. So many commentators see that moment as the moment in which personal data protection has ceased to be only the so-called first world problem and has become a problem of the whole world. Of course, there is a number of acts adopted within the Council of Europe system that my country is also a part of, that some of them lay down this duty to establish the independent data protection authority. The convention, which is known as the ETS 108 Convention for the Protection of Individuals with regard to automatic processing of personal data, is one of those sources, but this convention does not lay down explicitly this requirement to establish such an authority. However, the additional protocol does, and this additional protocol lays down several principles which are followed by basically all European countries. So one of these principles is that the countries do have institutional autonomy, so it is up to them to decide whether they will have one or several authorities in charge of the protection of personal data. And such an authority or authorities must have powers of investigation and intervention. They must be empowered to hear claims which are lodged by natural persons. They might exercise their functions in complete independence. Their decisions must be appealed in a proceedings before the courts, and there is also a principle of cooperation between these authorities. Also within the Council of Europe system, there is another protocol amending the Convention for the Protection of Individuals with regard to automatic processing of personal data, which is known as CETS 223. And this protocol has not yet entered into force, but it reinforces powers and independence of data protection authorities. And finally, since my country is not yet a member state of the European Union, we do have some connection with the EU system through the Stabilization and Association Agreement. And under Article 81 of this agreement, Serbia is required to harmonize its legislation concerning personal data protection with EU law. And this also includes indirectly the sources of the Council of Europe's legal system. And there is also explicitly a duty to establish one or more such independent authorities. And the first attempts to regulate this area in my country date at the end of the 1990s, so before the Stabilization and Association Agreement was signed with the European Union. And in that period, we can find some traces of modern legislation. Usually these acts which were adopted at that period were not properly enforced, so they remained, as we say, dead letter. And this is also the case with, for example, the first Competition Act we had. It was also adopted somewhere in that period and was not enforced. We could say that the true start of this a branch of law is the 2008, when the first EU harmonized act was adopted, as well as the strategy for personal data protection, and the National Data Protection Authority was established at that moment as well. So this, as we can say, main piece of legislation remained in force for, as you see, 10 years more or less. In 2018. A new law was passed that is still in force. The main reason for the adoption of this 2018 law was to harmonize Serbian rules with GDPR. So the Data Protection Authority has quite a long formal title. It is the Commissioner for Information of Public Importance and Personal Data Protection. So as you can see, this authority is in charge of enforcing two sets of rules. The rules allowing for access to information of public importance, and then following the adoption of the 2008 Personal Data Protection Act, it was expanded to enforce that law as well. I will not detail on different rights that specific data subjects have, because they are generally harmonized with GDPR. It's something you also have in your legal system, so there is no need to go into more detail there. Just to mention some of the rights: the right to be informed, to access personal data, or, for instance, the right not to be subject to a decision which is based solely on automated processing, including profiling, if such decision produces legal effects concerning to the data subject, or affects the data subject in a similar matter, or the right to lodge a complaint before the Data Protection Authority. If we analyze the main duties and responsibilities of the Data Protection Authority in Serbia, we can say that these inspections that are undertaken by the Data Protection Authority have proven to be crucial for the enforcement of these rules. And these inspections are undertaken either ex officio or under complaint received from complainants. I would say that one of the deficiencies is that there is not a great articulation of competencies and overlapping with competencies of civil courts. There are certain breaches of law which are set out as misdemeanors, for which the law on the protection of personal data prescribed fines. And the Data Protection Authority is authorized to initiate misdemeanor proceedings before the competent court. However, in certain cases which are more or less rare, these pecuniary fines for misdemeanors are set in fixed amounts, so the Data Protection Authority may impose these fines directly. But if a fine is not in a fixed amount, then the Data Protection Authority needs to initiate proceedings before misdemeanor courts. To conclude, I would say that the analysis, which is of course much more detailed in the paper, showed as the main deficiency of the Serbian system of personal data protection that there is an inadequate articulation of different protection mechanisms, particularly those related to the articulation between civil law proceedings and these administrative law proceedings before the Data Protection Authority. And this is something which needs to be better articulated either by amending the existing rules or adopting a subsequent act. Another issue which I would say is not common to the Serbian legal system, but specific to the Serbian legal system, but common to many other national laws, is that there is a need for better articulation of activities of different national data protection authorities, because nowadays they just communicate with each other, but there is no precise legal framework for such communication, for perhaps undertaking joint inquiries, which is something that should be better articulated, given that nowadays these breaches of privacy are generally taking place online, and internet is can be accessed globally. It is not something which is depending on these national borders. So for more details on this analysis, I would like to invite you to read the paper once it is published in the following months. And once again, I would like to thank you for your attention.